Hi everyone, in this quick video, and I'm going to call it a free lesson, where I'm going to just talk about a really common question that we get here at Salvo Migration regarding being able to stop working on a 457 visa if specifically you have applied for another visa. So it's very common for 457 visa holders to apply for other visas because the 457 itself is only a temporary visa. So often 457 visa holders will apply for things like partner visas or even general skilled migration visas or independently skilled migration visas through the points test to try to secure a more permanent visa without necessarily having to wait on the 457 and transition to permanent residency through that pathway. So the 457 is a good visa, gets you into the country and it allows you to work, but there is normally a qualifying period before you can apply for your PR through that particular sponsor. So a lot of people do end up applying for other visas. So inevitably what happens is those that are on the 457 visa will apply for another visa. And let's say, for example, it is a partner visa or a GSM visa like I just mentioned. Now, what happens is when you make this application, you do get a bridging visa associated to this visa application. However, the bridging visa stays in the background. You still hold a 457 visa until it has or expires on its specific day. So every 457 visa has a specific expiry date, which will vary depending on how long your particular 457 visa was granted for. But let's say hypothetically, just for this exercise, that your 457 visa expires on the 1st of January 2018. Okay, so let's put that down. So in this case, we have a 457 that expires on the 1st of January 2018. However, this 457 visa holder has applied for a partner visa sometime in November 2017. They are issued a bridging visa A, but they are still in their 457 until that expires. So the current rules surrounding 457 visas, and look, there has been a lot of changes, and there obviously will be more changes in March with the abolishment of the 457, but for now it's still relevant and it will still help people watching this video that are on 457s right now. The rule is that if you cease working for your employer in 60 days or thereabouts, essentially you're in breach of a visa condition. So you can't be out of work, or you cannot be or cease working for your sponsor for more than 60 days. If you cease working for more than 60 days, you're in breach of your 457 visa condition and your 457 visa can be cancelled. It initiates the process of the department eventually looking to cancel your visa. A really secondary common question that I get is, will the cancellation start immediately on the 60 days? No, look, it doesn't practically work that way because sometimes the department aren't notified that you have stopped working. So you may have stopped working more than 60 days ago, but the department may not be notified. The point is, at some point, the department may or may not be notified. If they are notified, if you have been out of work for more than 60 days, and if you haven't applied to transfer your 457 across to another sponsor, your 457 will be cancelled. So what happens is, if you've applied for a partner visa or a GSM or any other visa, and you have a bridging visa A that's been issued, and you stop working for your employer and your 457 visa is cancelled, what will happen is your bridging visa that was linked to the partner visa will be cancelled also. Okay, because this bridging visa is not only linked to the visa you've applied for, but it is linked to the visa that you held when you made the application for this visa. So think of it as a bridge between the visa that you held and the visa that you applied for. So if this visa is cancelled, it also cancels the bridging visa. So what happens then is people that have applied for these types of visas and have had their 457 visa cancelled must go to the Department of Immigration and apply for what's called a bridging visa E, which is a very restrictive temporary bridging visa that allows the visa applicant to stay in the country whilst they wait for the outcome of the partner visa and the GSM. Now, some general or common characteristics of the bridging visa E is that it has no automatic work rights. Okay, so you have to apply to remove the work restriction from the bridging visa E because they are generally granted with a no work condition. So you must apply to the department and demonstrate financial hardship in order to have that removed, which is not necessarily an automatic thing. It is a discretionary decision made by the department. So you want to avoid putting yourself at the whim of a department case officer and then being able to use their discretion in any case but particularly when it comes to being able to apply for work rights. You want to avoid that as much as possible, but in this case, it's unavoidable. The bridging visa E will have a no work condition and it must be removed. The other characteristic is that the bridging visa E does not allow you to return to the country if you were to depart. So holding a bridging visa E doesn't stop you from leaving Australia. What it does do though is it stops you from being able to come back on this particular visa. So unlike people that are on bridging visa A's, they can apply for bridging visa B's, travel and return on a bridging visa B, which is a travel bridging visa. Unfortunately, holding a bridging visa A does not allow you to apply for a bridging visa B, which means you can't apply for a visa that will allow you to come back whilst you're in the country. So if you depart the country on a bridging visa E, the only way that you can return in order to continue waiting for your partner visa is if you are entitled or eligible for a grant of another visa, such as a tourist visa or a student visa or some other type of temporary visa, which will not be an easy feat because often these temporary visas have requirements that you be able to show that you intend to stay temporarily and then you're going to go back home. Now, if you have a pending onshore permanent visa application, it's very hard to predict how the department may view your temporary visa application, your tourist visa application, or your student visa application. So be warned, it's not ideal to be on a bridging visa E because it restricts your movements in and out of the country, and it also could affect whether you can or can't work. So yes, you can stop working on a 457 visa once you've applied for your secondary application, but understand that there are potential consequences in terms of when your 457 visa is cancelled, how that affects the bridging visa you thought you were going to be on, and that you might find yourself on a bridging visa E with very restrictive rights. So I hope that helps, guys. As always, feel free to jump on our website and leave your inquiry, ask any questions. We have our Facebook pages, our Google Plus and Twitter, of course. We also have a private Facebook group, which is called Salvo Migration Community on Facebook. I'll write that down. So if you search Salvo Migration Community as a group on Facebook, you'll see that we have, look, it's increasing rapidly. We'll have close to 1,000 members now. And in there, people will ask their questions, members will ask their questions, and myself personally and a couple of team members will answer them as quickly as we can. So anyone who asks a question will receive an answer for now, for as long as we can maintain and handle the workload. But for now, we certainly are. So feel free to jump in and ask any questions in there. If not, you can leave your inquiry on our website and we'll get back to you as quickly as we can. Okay, I hope that helps.